Hey guys, Attorney Walter Hnot. My apologies for the video not being amazing. I have to use the camera that's on my computer as opposed to the giant one up there because I don't have the power supply. I left it in Florida. I'm in New Jersey working on the farm. Let's get right to it. Please remember to like, subscribe, ding the bell, and leave 5-star reviews. Let's get right to the point of this video though. Okay, the questions we're going to answer, and I'm going to try and do this more with my videos where I outline specifically what we're going to cover. The questions we're going to answer are, what is a vocational expert? What is their purpose in a disability hearing? Supplemental security income, Social Security disability insurance, or even outside of the hearing? Why do judges use them to decide if they are disabled? If the claimant is disabled, and why did judges not use them, these vocational experts back in the day? So let's get right into it. Now, remember, this is going to be a simplified version. This is going to be where I make it make sense for the average person, because if I just read from, some website what their definition is, it's not going to make sense. The rehabilitation, certification, all that, it's just not going to make sense. What is a vocational expert? They are a work expert. They study jobs. They study vocational profiles. They look at, from the SSA's perspective, 2 main books, but the one we're going to focus on is the Dictionary of Occupational Titles. The Dictionary of Occupational Titles. Inside that book, they have tons and tons and tons of jobs. If you go to Google and type in, Dictionary of Occupational Titles, SSA, what will pop up is basically a website which allows you to go ahead and type in keywords to find any and all jobs in the national economy. Now, we're not going to go into, is this book up to date? We're not going to go into, is this a great book? Does it accurately describe things? We're just focusing on what are vocational experts. So they use this book to go ahead and take your work and see what jobs are similar so that they can look at all of the little, clarification points. What's your reasoning level? What type of education does it require? How long does it take to learn the job? And they classify it within this list of jobs. That way, when we look at what you did and we look at what this, actual output is, we can start to classify things based off of it. It's a reference chart. That's all it is. Now, let's go into what is their purpose? What is a vocational expert's purpose in a disability hearing or even outside of that hearing? So sometimes judges will use vocational experts. They're much more common than they used to be. Way back in the day, 15, 20, 30 years ago, they hardly used vocational experts to the amount they do now. I mean, they've got them in pretty much every hearing all the time. There was one judge in Orlando who never used vocational experts. He passed away. But basically, I think over the past 6 or 7 years, every single judge that's in Orlando now uses a vocational expert for every single hearing. Now, let's go into this real quick. All right. The bottom line, very important. The bottom line is, what is their purpose? It's complex. I'm going to break it down. There's this big element chain, right? The 5-step sequential process, right? These are the elements, 1, 2, 3, 4, 5. And the most important elements for a job expert are the last 2. That's element 4 and element 5. Element 4 is, can you do your past work, right? Whether it was skilled, unskilled, semi-skilled, right? Element 5 is, can you do relevant, transferable, skilled work or unskilled work? Put another way, element 4 of these 5 elements, right? So they're at the very end. Element 4 is very simple. It's basically saying, hey, okay, can you do your past work? If you can do your past work, you're not disabled. They're there to answer that question, or rather assist the judge with answering that question. And then the next part of that, element 5, is, can you do any other jobs in the economy? So let's say you couldn't do that job, but could you do a simpler job? Could you do a job instead of in the medium category? Could you do a sedentary job, a sitting job? 2 out of 8, you're basically standing or walking, and then 6 out of 8, you're sitting. Could you do that job? So their purpose is to categorize the jobs you used to have for element 4. That way, the judge can ask questions called hypotheticals. Hypotheticals are fast-paced, very aggressive. The attorney has to really be thinking during that part of the hearing. And what happens during that is essentially the judge will ask the vocational expert okay, I want to ask you a hypothetical question, right? Hypothetical person with these limitations. And then the judge will outline limitations that this hypothetical person, and they're really just talking about the claimant, but this hypothetical person, right, would potentially have to limit their ability to do jobs. Remember, we're focusing on two things: the jobs they did and other jobs they might be able to do, right? So the judge will say, okay, I'm going to give you a hypothetical question. The claimant can only lift this much, can only occasionally do this, frequently do that, can never do this, blah, 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 blah. Outlines the limitations of the claimant. Then the vocational expert goes, okay, of the jobs that the claimant used to do, and we'll have like this job, this job, this job. And sometimes a vocational expert will have to like adjust it. It's in the book, the DOT is this, but as performed, right? It was performed in the heavy range. They had to lift more with that particular job. Okay. So what they'll do is they'll go ahead and, categorize, specify, outline what your jobs were. And then the vocational expert will say, based upon the hypothetical limitations that the judge outlined, whether or not, right, the claimant would still be able to do these jobs, whether those jobs would still be on the table. If they're not, the fancy terminology is called work preclusive scenario. Okay. So if we say a claimant is going to be off task 5 minutes every 30 minutes, including the 10 minute, 30 minute, 10-minute breaks every 2 hours are allowable, then that means, bottom line, that is a work preclusive scenario. There's no past work, there's no future work, there's no other jobs that the claimant could actually do. Cool. All right, so we got that. So the judge is looking at element 4. Can you do your past work? The judge is looking at element 5. Could you do other types of jobs? The vocational expert receives a hypothetical, which is just a sentence, a really long one, the most run-on sentence you've ever heard, that includes basically all of these limitations that the claimant basically has to be able to do the job. Cool. You've got that now. Awesome. Now, why does the judge ask multiple hypothetical questions? Well, the first hypothetical question is usually about your past work. Could you do your past work with these limitations? Then they proffer additional jobs. Now we're on to element 5, right? Could you do other work? And they ask, okay, looking at this other work, give me some jobs. What other jobs could be done? The vocational goes squiggle through their book. I'm just kidding. They don't use a book. Some of them have a binder, but it's all computer at this point for the most part. Which is ironic too, because the youngest vocational experts always have a binder, and the older vocational experts, it's all computer based. You would think it'd be like the flip, but I think like the younger vocational experts, they like have their like cheat sheets and stuff, and they're like, okay, here's my quick yada yada. Whereas the older ones, they've been doing it forever. Like, they lived in caves and they were still studying what jobs there were to do in a cave. Anyway, I'm sure if a vocational expert watches this video, I've insulted them, but that's okay because we all love them. All right. Now, with that said, when we get to hypothetical 1, can they do their past work based on these limitations? Yes, Your Honor. No, Your Honor. Work preclusive, not work preclusive. They can do this job. They can't do that job. Blah, 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 blah. They give an answer. All right, let's say that it's work preclusive because we don't want to make this video too long, and they can't do any of their past work. Then at that point, what happens is they go ahead and go to the next set, which is, could they do other jobs based on that same hypothetical of limitations? Well, okay, so vocational expert, are there other jobs in the national economy that the hypothetical person would be able to go ahead and do in the national economy? Remember, national economy means any job anywhere. Alaska, Hawaii, Florida, Maine, anywhere. Okay. Now, with that said, vocational expert goes through, gives usually 3 jobs, right? That are part of a category, right? So you got the very heavy, medium, light, and sedentary. So he'll give 3, or she will give 3 jobs that are part of one of those categories. Cool. So we got that. So now that you get that the first hypothetical is about their past work, and the first hypothetical is used for other types of jobs that are proffered, usually 3 jobs from the DOT. The judge is going, okay, would there still be, would there be jobs? And the vocational expert goes, yeah, Your Honor, there's this job that the claimant could potentially do. And then the judge will go, okay, I have another hypothetical for you. The next hypothetical, howdy, Deb Carter, howdy. The next hypothetical that I have for you is basically, we're going to add these limitations. So imagine the hypothetical person suffers from this, can't do that, We reduce, the frequently down to this, and we make that hypothetical person more limited in their ability to go ahead and basically do work stuff, right? Okay, then the judge goes, okay, are those jobs still available, right? And the vocational expert goes, well, that would get rid of this job, we get rid of that job, but we'd keep that job, right? And this is all before the attorney cross-examines. And I'm not actually going to do any of the cross-examination stuff in this video because it'll make it too long. So the hypothetical, okay, so we limit the claimant. The vocational expert comes back and says, 2 of those jobs are out that I proffered, but 1 of those jobs still remains, right? And the judge can end it there and say, counselor, any questions for the vocational expert? And then basically, or the judge could go ahead and continue. And the judge could say, okay, I have another hypothetical question. Another hypothetical question. You got to wave the fingers. It makes it all better. It makes it better. Another hypothetical question. What if the claimant were to be off task for, let's say, 20 minutes of every hour with the available allowable breaks? And what if the claimant was to miss 2 days a month? Would that final job still be available? No, Your Honor, that would be a work preclusive scenario. Okay, cool, awesome. At that point, the judge is showing you a leaning towards this person might de facto be disabled. But you'll almost always hear in a hearing 2 particular things: time off task and missed work, right? And the standards are, 10% of a workday, you're allowed to be off task. Anything above that, it wouldn't work. Be work preclusive, you'd be fired. The other thing you're almost always going to hear at the end of one of these disability hearings is basically when it comes to how many days a month you can miss. Some vocational experts give a different decision, right? Give a different, they give a different, well, you can miss this many over this much a year, but the standard is 1 day a month. That's the standard. That's what you usually hear from most of them. Okay, so if you miss more than 1 day a month, you're out, right? All right, cool. Can't work, won't happen. Hypothetical person is not a worker bee. All right, good. Now, with that said, I want to take a moment and explain what happens sometimes that's rare. Sometimes we won't have the full hearing. Sometimes the judge will send interrogatories to the vocational expert, questions to the vocational expert before the hearing or after the hearing. That means they're not in the hearing, even though it might be telephonic, video telephonic, or in person, but it could be before the hearing or after the hearing. Those questions, interrogatories, are submitted to the vocational expert. That's okay. That's a little bit of, there's some trial tactic stuff going on there. You can always ask your attorney about it. Obviously, you guys know me, most viewed disability attorney in America on YouTube. If you have questions, call me every Thursday night. I go live 8 to 10 p.m. Eastern Standard Time. If you want to sign up and be a claimant of the firm, 9 to 5, give us a call. We'll go through the claim with you. But if you're already found disabled or you're already represented and you want to keep that rep, or you can't get out of that relationship with that rep because they won't withdraw fees, call me on Thursday night, okay, 8 to 10 p.m. That's when I go live on YouTube. Call in with a fake name. Now, why do judges use these vocational experts for disability claims, right? Because way back in the day, they didn't use them. The judges just kind of did their thing. The reason why is that Social Security disability hearings are slowly evolving into a more expert-based process. What do I mean by that? So way back in the day, you had the judge's clerk, this chair is going to break on me. I can feel it. You had the judge's clerk. You had basically the judge. You had the claimant. And you had the attorney. But then they started adding more and more vocational experts to it. And the reason why is a really important one. The first element of disability benefits is a financial one, right? Are you earning too much? If you're earning too much, you're not disabled for their rules. I mean, you could have every limb gone, but you would still, if earning too much, not be disabled under their rules. Now, with that said, element 2 is about a time duration. Have you been disabled 12 months or more, or is it terminal? Like, your impairment could last 2 months, but if you die within 2 months, that's the expectation. Element 3 is a medical severity element. How severe are your impairments? A lot of people come up to me and they're like, I'm going to go on disability benefits. I've got COPD. And I'm like, dude, I just saw you run up the stairs. You're definitely not going to pass the FEV numbers test. And that's the reality of knowing mild, moderate, severe, and extreme where you are. And you've got to at least have severe to be found disabled for a particular impairment. So what happens at element 3, right, is we learn about all of the severity levels of the claimant. We learn about essentially how this claimant is having difficulty when it comes to their medical diagnostic impressions. Like, how bad are they? What's going on? Did they have surgery? Did they have MRIs? Did they have x-rays? We learn about that stuff at that step. Once we know at element 3 what's going on with all their medical, right? Once we've got a good idea, we understand it, we figured it out, right? Then we go to element 4, which is all about, look, if one of their impairments isn't severe enough in itself, then we look at all the impairments and say, would this person not be able to work? Because if you can't work, you can't earn money. If you can't earn money, you're disabled. That's the whole giant theme in disability benefits. I hope I'm explaining this okay. You know, to me, it's like I live in, so I swim around in the soup and there's a chicken nugget in the soup, and I get it, you know. All right, so with that said, I want to go into essentially why this is important. Judges back in the day would just act as a vocational expert in themselves. They would just look at it and be like, okay, I don't think this person can work. Their impairments are so severe based on the Dictionary of Occupational Titles and the hypotheticals that I want to ask. I'm going to approve or deny, yada, yada. But then there were a lot of lawsuits, a lot of appeals council, federal district court, circuit court, even some Supreme Courts that equated to the judges losing because they didn't have the background of a vocational expert. Interesting, right? Important. Now, what's happening with the future of disability hearings? Not only will there be a vocational expert present, but very likely there will be a medical expert present as well. This can either make a claim go very quickly, or it can make a claim a very difficult uphill battle, okay? But today's about vocational experts, so here's the bottom line. Why do vocational experts come at the end of the hearing, right? So the beginning of a hearing, we do our intros, right? Hi, I'm this person, you're that person, AOD, DLI, we get all that junk out of the way. Then we go to the examination of the claimant. Mr. So-and-so, date of birth, current name, or date of birth, current age, left or right-handed, social security number, where do you live, 2-story, 1-story, blah, blah, blah. We get all that junk done. Then we do cross-examination. You said 10 minutes ago that blah, 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 blah. Can you explain to me in further detail? Or out of the following, environmental restrictions, cold, hot, dust, loud sounds, vibrations, bright lights, blinking lights, pulmonary irritants, which of those triggers your impairments? We go through all the cross-examination types of questions that happen in a disability hearing. And then after that, what happens is, right after that, we go ahead and then get to the vocational expert. And it makes sense because the beginning of the hearing is we're getting everything lined up so that it works out. The second part of the hearing, we're doing, we're figuring out what's going on with the claimant. We're figuring out what the problem is with the claimant, right? And then the third part of this whole thing is we bring in the job expert. The job expert, now that we know the medical problems and we've got the testimony of the claimant, we've got to ask, can this person go and do a job? That's the whole point. Can they, if not doing their old jobs, do a different kind of job? Something that's maybe easier, something that's maybe more sedentary, something that doesn't require lifting as much. That's the purpose, because it validates, using a scheduled system, the ruling of the judge as to whether or not you're disabled based on what's called a vocational allowance. A vocational allowance is where they look at all of your impairments because one of them wasn't severe enough. So they got to consider all of them. And when they consider all of them, they look and say, could this guy, could this woman with all these impairments still do this job or these much easier jobs? And the vocational expert answers that question on the record for the judge, which is the missing link to getting that, decision to stick on the record. All right, cool. We've gone through this stuff. Now, let me go through one final thing. There are things that I don't know about vocational experts because I'm not a vocational expert. I'm not certified to do that stuff. I interact with them all the time. I read some of the books that they read. But the bottom line is, if you have additional questions or you want to check in, this person has not paid me at all to say this. He may be pissed off that I'm actually putting his name out there for you to give him a call because he might get too many calls. But the point is this, and I think this is really, really important. If you want to learn more about it, if you want to talk to somebody who's a pillar in the industry, and I'll tell you a quick backstory. I don't know if it was my first hearing with my law firm, because remember, 9 years ago plus, I started my law firm. I don't know if it was the first hearing or it was the second or third hearing, but he was the vocational expert way, way back in the day. That was part of one of my earliest hearings. And so as a bottom line, he's a pillar-like individual. And what I wanted to go ahead and do is, if you have further questions, I'm going to actually reach out to him. Like I'm thinking about this right now, whether I should. I'll do it. I'll reach out to him via email. Okay. And I'll ask him if he's willing to come on the show and explain from his perspective what his job is, what's important about it, what he does, and how it works. Now, with all that said, guys, I just want to go ahead and remind you, please be respectful when you go ahead and interact with these other professionals in the industry. And, keep in mind, this is a guy who does a lot of federal hearings. But, it doesn't have an email on here. It just has a phone number and the website. So you could always go to the website and submit something through that. But Devin's an amazing guy. But here's his contact info right here. This is who he is. I know you guys can see that okay. Yeah, I can see it okay. Super cool guy. Basically, go to his website, VOC expertservices.com. Go check in with him. He's one of the experts in the industry. I'll reach out to some of the other vocational experts and ask them to come on the show because there's all this mystical stuff about, like how does the vocational expert, give the judge the right answer? What if the vocational expert disagrees with the judge? There's all this mystical stuff that people, there's no videos on YouTube about it. This channel obviously gives you a lot of detail, a lot of information. Let's reach out to some of these guys. I know a bunch of them because obviously I interact with them all the time. Let's get them on the channel. Let's get them talking about how the system works so that you can understand it better, because these guys get hired all the time. They get hired all the time by the federal government. They get hired by the VA. They get hired by the disability fund to give testimony about basically the vocational capabilities of a person. Because we got to know, can the person work? If they can't do their past job, can they do other jobs? All right, guys, I'll catch you a little bit later. You have an absolutely wonderful day. I tried to unlink that person that was sending all that stuff in the chat, so I hope I fixed that. Either way, thank you so much, guys, and we'll catch you later. Please remember to like, subscribe, tickle the bell, and leave 5-star reviews. All right, thanks so much, guys. Bye-bye, guys. Bye-bye.